that paragraph 18, which didn't help me earlier, but I'm hoping is going to help me now, is where he's giving an explanation of what he understands to be happening regarding witnesses. And he's contextualizing that to say, I'm just not willing to take a risk.
Yes.
He's not being definitive. He can't be definitive.
Well, in paragraph 10, he says, it is well established that there has been assassinations and attempted assassinations of witnesses who have appeared before the commission or who are scheduled to appear before the commission to testify, right? And then he attaches those articles.
That we just spoke about, yes.
What I'm putting to you is he makes that statement, but in fact, as a matter of fact, there is nothing that says the witness died because he testified.
Yes, I have no difficulty in accepting that. I have no difficulty in accepting that.
All right. Now, having done that, can we, and in light of your discussion with the chairperson, can we have a look at the documents that you've attached as a threats?
Yes.
Because I would like to, firstly, maybe let me foreground it this way. Your client is a businessman, right? That's what he tells us in his affidavit.
Yes.
He's a businessman. Your client tells us in his affidavit, at least in the annexures that we have here, he's a member of the ANC.
Yes.
Okay, so
that's not in doubt.
We've got those facts, right? Now, I look and please assist me to the extent that I may be misreading these annexures. Now, my reading of these annexures, except the last one that we will get to, none of these annexures, the first is at page 14.
I'm there.
There is absolutely no reference to his appearance before the commission.
Yes.
Previous appearance and anticipated appearance, right? Nothing about it makes that connection. Do you accept that?
Subject to the caveat that factually, yes, I accept it, but my submission in respect of this annexure is that the timing of it is suspicious, alternatively convenient, given when it comes. So factually, does it mention the commission? No, it doesn't. But in context, the submission is that it's related, inextricably related, to his appearance here and the evidence here.
When he first appeared.
Yes, yes, that's right.
And this would have been, he would have received it, if he did, he would have received it after the court application.
No, because if you look at the page 14, it says Sunday.
Yes.
And I think the Sunday that's referring to is Sunday, the 8th of February.
And the application was issued when?
The application was heard that Tuesday, I think that was the 3rd, and then we were in front of you and the order came out on the 5th, and then we were in front of you on the 6th.
Okay, so the application was in the preceding week before he appeared before us?
It was in the same week. It was heard and determined in the same week.
The chronology I'm trying to clarify is an application was issued?
Yes.
The agent application was issued?
Yes.
And you were heard?
Yes.
Before he came before us?
Yes, 3 days before.
Okay, and so this is issued only after he's appeared before us?
Yes.
And in the court application, he does mention that he's going to be appearing before us, but he doesn't get a threat. In the period between the court application and his appearance before us, there's no threat received?
No, there are none.
Okay. So we've cleared that page 14 doesn't make any reference to his appearance before us, right?
But may I say something in response to that? Isn't that ironic? Because when he is in the urgent application, and the possible outcome of the urgent application is maybe he doesn't have to testify, given what the skirmish was at that moment in time, there is no issue. There is no threat issued. But just thinking about what the commissioner has put to me in the timeline, after he comes here on the 6th, and one of the outcomes from the 6th is the chair's order directing, you will appear on 9th and 10th, not even 2 days later than on the Sunday, the threat is issued.
Yes.
And the threat is then about whatever is happening here, about your life and your house. And even though it doesn't mention the commission, I would just point to the timing using the exact facts that you have put to me, Commissioner Baloyi, is, as I said, either ironic or convenient.
Well, yeah, maybe it is convenient. I think the point that I'm making to you is, well, the first time anyone knows that your client is coming to the commission is not when he appears here. That's a simple point I'm making, that the first time it is public knowledge that your client is going to appear before the commission is with a court application. That's the simple point I'm making.
Yes.
That's the simple point I'm making, as a matter of fact.
Yes.
Yes. That's all I wanted to accept.
I can give that fact because
Okay.
those are the facts. I can give
Okay.
the answer. What I'm trying to resist.
I'm at fact establishing fact stage.
Before we go there, potentially, yes.
Potentially. So we've established page 14 does not make any reference whatsoever. So this threat could, on this page alone, the source, the reason for the threat could be anything. Could be his membership of the ANC,
Yes.
could be his business associations, in any of that,
Yes.
maybe even the commission.
Yes.
But we have no basis
No,
on
but-
page 14 to link it to the commission.
Yes, and well, no explicit basis to do so, but.
No basis
but-
at all. What I'm
but-
suggesting is there's no basis at all.
No, that's where I need to resist that conclusion with all due respect, because
Yes.
by the same token that you put up two other possible explanations,
Yes.
his membership of the ANC and or his business interest, why is the commission and the timing of the commission seemingly discarded, but
No,
two
I've
alternatives are.
included the commission. I've said to you, it may be the
Yeah, okay.
commission.
Well, then-
But I have no basis
Yeah, yeah.
to say it's one or the other.
So-
There are three possible bases from what I've put
Yeah.
to you, I've proposed to you. There are three possible bases.
Or more, we
for
don't-
the-
we
for
don't
the-
know.
for the- absolutely.
Yeah, then
Yes.
we're ad idem, thank you.
And then A2, we've agreed, it says nothing about, it doesn't help anything, right?
That was the
Because-
attempted assassination.
Yeah, no, this is the death, in fact, of witness D, him being shot,
The one at page 15.
15 years.
Yes, the apparent hit, sorry.
Okay, so this has nothing to do with being a reason, providing a reason for your client to fear appearing before us.
Well, you've heard me on that already, and I've tried to read that in context for you, having regard to the other paragraphs in the affidavit where he gives an explanation regarding how he sees these things happening, which animate his fears. So factually, I accept your correction
Yes.
of the record like I did earlier with Commissioner Kumalo,
Yes.
but with all due respect, I don't think that that detracts from the underlying point, which is that even if he's misunderstood the correct facts regarding what happened in respect of this witness, that is nonetheless something that animates the fear, which triggers the in-camera, and that takes us to a reasonableness assessment. But
Yes.
so I
Of
think
co-
we're
Of course,
at idem.
it's up to us to look at these that he's referring to, finally to determine whether that fear is reasonable or not.
Yes.
So it's not for him to simply say,
Yes, but
I'm animated, I'm concerned because of this, and that's it. Then we must make a decision that favors him.
No, of course.
We have to assess the reasonableness of his fear, and we can only assess it on the basis of what he's relying on, right?
yes,
For
I
the order
accept that.
36. Okay.
But may I just say that, and I speak subject to correction,
Yes.
but the answering affidavit doesn't make these points about what could have animated my client's fears and says, oh, well, you know, you talked about two witnesses, but actually this is the correct factual position. And so in as much as obviously the commission needs to correct the record where there are mistakes and apply its mind to the issues as they are, the point that I would make is that the commission fails to correct that animation regarding the fear. And
Yeah,
so,
but what are you saying? Okay, now that you're saying this, what are you saying we should do with that? Just because the commission doesn't deal with it in the way that you say they haven't, are you
Yeah.
saying it's not within our powers to determine on the basis of what he has placed before us? Because maybe let me suggest this to you. As I see it, is even if they had chosen, the evidence leaders had chosen not to answer, we still have to determine your application on the basis of the case you made.
absolutely.
Yes.
But
So it's irrelevant. It must be
Well-
relevant for purpose of my engagement with you. It's relevant for purpose of you replying to Ms. Hassim, but for purpose of my engagement with you, it's irrelevant that they didn't say what you're raising now. What's relevant is your answer to what I'm raising with you.
Yes, and may I just say that I have no difficulty regarding the proposition you put to me regarding what you need to do. Absolutely, I'm not disagreeing with that. All I'm highlighting is that even his mistaken approach regarding what animates his fear is not rebutted by the Commission as a mistaken basis to animate the fear.
Okay.
So,
Mr. Premhid, we have a few times said the evidence leaders are wrong in what they have said. So it doesn't take the matter any further for you to say, well, they are not saying it. As I say, you'll reply to her if she tries to make that point.
But I'm sorry, I think we're speaking slightly past each other, Commissioner,
Yes.
with all due respect. I'm not taking a pleading point in the sense that, the answering affidavit doesn't put up a rebutting version, therefore on Plascon Evans. As the chair rightfully said, there are rules that apply in a court proceeding which do not apply in these proceedings.
Yes.
All I am saying, insofar as your assessment of reasonableness is concerned and what animates the fear, is that even if he was mistaken at the outset when the application was launched, the Commission, who is in possession of the true facts and the full facts in a way that we are not necessarily in possession of, could have said under oath, here's some facts that you need to think about regarding animating your fear. And I'm not making the pleading point. What I'm saying is that may have reasonably or not reasonably adjusted my client's position regarding the in-camera. And so all I'm saying is that where the Commission itself doesn't put up a version to disabuse my client...
What version could they possibly put up, Mr. Premhid?
Exactly the version you put to me now, Commissioner Baloyi.
No, what version have I put to you?
You put to me, sorry, maybe I shouldn't call it version, maybe I should say you put two facts to me. It's even stronger than a version. One was about the witness D or F or X.
Mr. Pretorius, that he died of suicide.
Yes,
he was not a witness before us.
And then there was the other...
And you're saying the Commission should have said that in their answering affidavit?
Well, if they did say that in the answering affidavit, that would have given us basis for pause. And it would have invited my client to respond to that and maybe then explain why he's nonetheless afraid to come and give open evidence. Or evidence in an open session.
When your client or when a deponent makes allegation in an affidavit and they say these are factual allegations on which I rely, such as Mr. Pretorius, he died, he was a witness and he came to testify and subsequently he was killed. Where does he get it from? It's for him to justify that statement. It didn't have to take, there's no requirement that the opponent should have said, but that's not what happened, so that he can formulate his next response or next position. Your client asserts, the deponent asserts as a fact, and the chair sought to engage you.
Yes.
Where do these facts, the stuff that is alleging, where does he get it from?
Yes.
It's not open to you, at least from where I sit. It's not open to you to say, well, the evidence leaders should have told us that he was never a witness, when it is your client who says he was a witness and he was killed because he was a witness.
Yes, I think where there's a potential, where we're potentially speaking past each other, is that I accept what you say regarding the affidavit, the contents, the accuracy, and whatever the case may be. All I'm saying is that in response to that and putting the facts to me in the way that you have, should nonetheless not result in my client not enjoying a consideration of all the other factors that he puts up.
Oh, and that's if that's what you're saying,
yes,
you don't even need to say it, of course. His application will be considered on its merit.
Then we're ad idem.
Okay. All right, let me continue the exercise that I was doing with you. The next annexure is A3. A3 is a continuation of that witness D, Mr. van der Merwe's killing.
Are you at page 20?
Yeah.
Oh, sorry, 22. I see 22.
22. It's at 22. I just want confirmation. It's a continuation, right?
Yes, it's another article regarding
that same story that we have now discussed.
Yeah.
Okay. And then the next one is at page 24. Okay.
I apologize. Yes, Commissioner?
All right. It's at page 24.
I'm with you.
All right. It starts off with tell your every driver at, okay? And then it says tell your every driver at that fight has started. And we will make sure that everywhere where there is that company, we take them out. So there's a reference to his business there. And you can correct me, which on the face of it seems to be threats related to his business or emanating in respect of his business. And then the next one says, before you appear, the commission will show you and your eyes boy, go to the commission, we will stay behind and take care of your staff. Now, for the first time there is mention of the commission, but in context of the earlier messages, it seems to me that in fact the threat relates to his business affairs, because it mentions his business.
Yes, but I mean, with all due respect, we know what Ndumeni tells us about how we're supposed to interpret a document as a whole and all those kinds of things. And with all due respect, if we can't interpret this document in isolation from two critical messages that come after the business being mentioned, which what we say gives color and context to the entirety of the application. And may I just finish by saying this, is even if we assume if I assume in your construction of the message that the first two messages are aimed at businesses, what does it matter in circumstances where the subsequent two messages, which don't mention the businesses, sure, are saying, go to Madlanga and see what happens to you? Yeah. So I don't know whether,
So they will go to Madlanga and we will show you and your eyes boy. So the eyes boy surely has nothing to do with coming to the commission, because we are not calling anyone that's referred to as eyes boy.
Well, that depends on, that depends whether someone you have called is or isn't an ice boy, depending on what your final report says. Yes. I mean, I don't know. I'm not going to speculate, but I think with all due respect, this is the difficulty I'm having with the interpretive exercise, is that we're picking out parts of the message.
No, I'm not. I'm actually saying in context.
Yes.
I'll do exactly what you say.
Then I apologize. It might be me who's
and I'm
picking
saying
apart.
in